Poker has the intensity of trying a lawsuit, and it also has the trepidation of losing and reading people. And people think poker is a lot of bluffing. It's not a lot of bluffing. It's just bluffing at the right time.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to share part 2 of this conversation with Larry Kern. Later in your career, it seemed like you spent most of your time trying cases, playing poker, playing golf.
Correct.
All of those sound kind of like, for lack of a better description, adrenaline junkie types of activities.
Absolutely.
I'm guessing those 3 things are things that you enjoy.
Yes.
How did you manage to set up your career in a way where you were able to do the 3 things that give you joy most of the time?
Well, one thing that's kind of sad, and I'm looking backward, it never was, but now it's kind of interesting. We don't have any children. That's a huge thing if you didn't have children. You could have never done what I did and be a decent father. So that was really one thing. Secondly, I gave up golf for 25 years because it's too much time and it should belong to a club and all that. The poker has always been there. I played poker clandestinely my whole life, even in college. So that was always there. In 1988, I made some money, and I bought another house away from here in Discovery Bay. And we still have a second home in Discovery Bay. It's just the third home we've had there on the golf course. And in 88, we bought that home, and I'd play golf. The trying of lawsuits, I had a wonderful situation with John Noda. He worked the files up, and I only did the stuff that he thought I should do. And some stuff he says, no, you can't do it. You can't take this expert depth. You don't have the patience, which is always kind of humorous. But he controlled those files pretty much. And I had total control over, most lawyers didn't know that, I had total control over trying the cases, 99% of the ones I tried. So we never let people know that. They always thought it was from the carrier or whatever. But when you represent the insurance companies, you don't have control. I mean, I guess it was around the 90s, we were doing AAA work. And you can hear this too, AAA. You lied to me in a settlement conference telling me, hey, you had so much money. You had more money. And after that, and a judge lied to me also. After that, when a judge says, what do you really have? I never told him. Before that, if you knew the judge, I always told him. But after that, I never told him. Never told him straight how much I had.
Going back to 88 and the second home, when you said you made some money back then, was that money made in playing poker or in law or some combination thereof?
No, it was the office had grown to 3 associates. They weren't partners. So I had a sizable sum of money like plaintiff lawyer does once in a while.
I'm sticking on the poker just because you and I think Jim Brosnahan is also a big poker player.
Different levels, but yes.
One of the reasons I find it interesting is because from an outside observer, it seems like poker is a lot of reading people.
Yes.
Did you find that your engagement in poker made you a better trial lawyer, or your engagement as being a trial lawyer made you a better poker player? And what sort of wisdom might you be able to share with our listeners in terms of how one might view the other?
Here's an interesting comment. We were on a panel, Jim Brosnahan, about picking a jury. And I'm not comparing myself to Jim, totally different lawyer, but I've tried a lot of cases. And somebody asked Jim, what's the difference between you and Larry if you're picking a jury? And he says, oh, it's real simple. If we're in LA, I ride the bus and I look at, the jurors, and I go out and look at them and I bill it. And Mr. Kern, when he's down here, he does the same thing, but he doesn't get to bill it, which is, I thought, humorous. But in answer to your question, the people ask me, what are the three most important things to be a trial lawyer in your life, my life? And it is 1, driving a cab, 2, playing poker, and 3, I guess, luck or being in the right place and having getting the opportunity. And why that is, poker has the intensity of trying a lawsuit, and it also has the trepidation of losing and reading people. And people think poker is a lot of bluffing. It's not a lot of bluffing. It's just bluffing at the right time. And driving a cab gave me the opportunity to be with all kinds of people and experiencing the whole process of all kinds of people. And playing golf, the most important thing for me was playing golf. I played as a youngster, I was good, and I played with older people. I got to be able to appreciate the psyche of a lot of older people. And those 3 things, I think, were most important in my career of what I did. I just did a lecture for a law firm on picking a jury, and I don't want to really say it because they're well known enough. But I told them they don't have to worry about picking a jury. They never have a bad case. Just don't alienate them. Don't be something stupid. And as long as you're nice, they're going to like you. And I thought of that as your companion. I call her my girlfriend, Cynthia McGuinn. I mean, she can't lose a jury selection. I mean, you saw the 2 of us pick a jury. I didn't lose it, but I can't win. There's no way as far as picking a jury.
You did use a tool that I hadn't seen before that I sometimes incorporate.
What's that?
I remember you starting your jury selection and walking over and borrowing the stapler from the court reporter. And you said to the panel, do you know what this is? And the panel said, a stapler? And you said, no, this is a durometer. And you laid it on the table.
Oh, you use it.
And on occasion, in the right environment,
right,
I have found that has been something that has helped me on cause challenges.
Yes.
To get people in a more amused way to acknowledge that, yes, I am a cause challenge, get me off.
Well, we'd have to go in a long time about using this durometer or jury meter, but the original, I want to give credit to the original lawyer, is Steve Tigerman.
Oh, really?
Yeah, I got it from Steve Tigerman. And it's terrific on challenges. I had a good judge up in Stockton who defending a paraplegic, horrible case. I got 22 challenges for cause in one case. No one's ever done that. And I've had the judge referring to the juror, where are you on Mr. Kern's meter?
That's awesome.
Yeah, that is awesome. And he would say, is there any way to change your reading on Mr. Kern's meter? No. Now, when you say you're biased or something, they'll say, well, you'll put aside your bias and you'll be fair and impartial. This is the worst garbage you could talk about. But a meter is insensitive. So the meter, they can say, no, I'm not going to ever change my view on a meter. So, yeah, it's terrific.
Between that and some techniques that Rich Schoenberger gave me about insisting on the entirely impartial language.
Right.
We did really well in San Mateo many years ago, and we ended up with 75 for cause in a case.
Really?
Yeah. And it was your durometer and it was Rich Schoenberger's.
If you have a good judge, you should be able to get an impartial jury.
You should. And with the number of jurors post-pandemic not showing up, I've found that judges tend to be harder on cause because they get crap from the jury selection pool about not burning through panels of 75. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. Talking a little bit about giving some techniques to a law firm, was that just on jury selection or was it on other things as well?
No, just jury selection.
What other tools did you give them in your presentation?
It wasn't so much the tools. I didn't talk about gerometer or jury meter to them. That's a personal thing. And I would use something, Miles said I used a stapler. I usually would use my glasses, and I'd put my glasses on the table, and I'd say, you think these are glasses. Well, they are, but they're not. And I always tell the court reporter, don't interrupt me, because I tell her the word jury meter. I'd let the judge interrupt me. I said, these are actually a jury meter. The judge would go, what? I go, jury meter, Your Honor. But for the purposes, we'll use the shorthand as just a meter, okay, not a gerometer. So what I do is I would look at the jurors and say, it's very unusual. I have a big advantage over Mr. Cooper here, because this will tell you where you're at now so far. So I'm going to put my meter of Mr. Jones over there, and you'll see what it does. Look at this. It goes all the way over to here. Now, I've already analyzed Mr. Jones hates cabs and doesn't like me or whatever. And I'd say, is that kind of fair? Mr. Jones, you're more leaning toward this other side. And that's what we're talking about. And they'll get very frank rather than talking about bias or prejudice. But the big plaintiff firm I talked to wasn't that at all. It was mainly I gave a proposition that you really have to be a lawyer because you're not second chair and you're trying a $100,000 case, as opposed to these multi-million-dollar cases, which settle most of the time. And just how to deal with the jury as far as your personality goes. You got to get the jury to kind of like you, in the sense that not that they're going to vote for you or anything, but you haven't pissed them off, that they're okay. Now, it's much easier on the plaintiff's side, assuming you don't have a crazy case, than the defense side. I think defense lawyers, they have to have good liability cases, 90% of the defense lawyers, or they can't do nothing. I don't put myself in that group. I could try a case of bad liability.
One of the things I remember, and I remember it specifically because of how well you interacted with the jury, and I'm pointing at your gerometer as I'm doing this, is when the jury came back and the jury talked to the lawyers who tried the case, and I think I still have the language pretty down, which was, Mr. Kern, we loved you. You were great. We just really didn't like your client.
Well, of course. I mean, that was a horrible case, and they were fair. They did a good job. But I think the biggest thing is that the jury, if they respect that you are straight with them, it goes a long ways. And one of the big techniques I always used, and it was more difficult with big cases in certain matters, I used to get up most of the time and say, ladies and gentlemen, I represent a cab company here and a cab driver. Would you raise your hand if you have an affinity to either one of those? Everybody'd laugh, and I'd say, let the record reflect that, unfortunately, none of these jurors have an affinity to my clients. Now, does anybody feel that they have an affinity to me? Anyone want to raise their hand? No. Okay. Well, that puts you in a different position as this defense lawyer. Now, the other thing is when I would get into a jury room with the panel, I would always look at the panel. There would be a number of people that would be frowning and looking at me, and you know that they don't like you. So you got a little upsmanship on who you're going to challenge for cause.
When you are making those reads of people, for those who have not had the same level of opportunity to engage in jury selection, do you feel it is more important to go with your gut on those visual reads versus the person who frowns at you and then says the things that you want to hear when you are actually doing the questioning?
Well, I think if you're going to gamble on a juror, one, you got to look at how many challenges you have left, and two, is the juror going to be a 4-person? That's huge. And 3, I always went on my gut reaction of whether I want them on if I'm not sure. One of the things I used, which is informative to any trial lawyer, if you can help it, and this is hard because you got to do it a lot, and lawyers don't get to do it a lot. Never telegraph a question. And I was on a couple panels with jury consultants, and they'd always say against me, and they'd always say, God, I would really like to do a case with you. I said, why? He says, because you don't give away anything. You just ask a question. Well, when I ask a question, I want to know if they're honest. And even if they're favorable to you, you can't take the gamble. And I remember a good example was I was trying a case, and I was a plaintiff, and a woman came in, and I must have been in my early 30s, and she was a really cool lady, about 50, and her husband was a lawyer of general counsel and assigned the cases out. In fact, I remember she assigned them out to Kaiser. I was a Kaiser arbitrator later, much later in my life, and signed them out to Kaiser. So she got a husband lawyer, and he's defense, and he assigns cases, and she's gone through a lot of trials. So I want to find out whether I want her or not. And she's real ingratiating. So after a few questions I asked her, I said, let me ask you this. The judge is going to tell you can't talk about this case, and you're going to be on the jury. And all of a sudden, some question comes up, and you don't know how to answer that question. But you know your husband would be a big import to giving an answer to that case. And you would never talk to your husband about the case. But let me ask you this. Would you have trouble not talking to him? That's different than talking to him. If you say, are you going to talk to him? She's going to say, absolutely not. But would you have trouble not talking to him? She goes, absolutely not. That's not honest. That's a lie. Now, it could be for me or against me. I don't know the answer to that. But I threw her off, and she waited in the hallway and told me how stupid I was, and she really wanted me, and I was cute then. So she liked me, and she's really mad I threw her off. But that's an example of not telegraphing a question. They can't read that question. If she just told the truth, I said, if you just told the truth, you're on.
At a certain point in your career, and I'm bringing us back to Melvin Belli, at a certain point in your career, did you have an opportunity to try a case against Belli?
I did.
Can you tell us a little bit about that?
20 years later.
Did he treat you differently because you had some sort of relationship earlier?
Belli's a strange guy. He seemed aloof on everybody. The case was Howerton or Howard. She was getting in a DeSoto cab, and the cab driver horribly hit the accelerator instead of the brake and pinned her in the door and ran over her right side, and she had a brachial plexus tear, and she was hemiparesis, injuries, all internal injuries down her right or left side. I don't want to get into, there was a dispute between Bill Cholas, the father of the Cholas, your contemporaries.
Yes.
There was a dispute over the fee, and Belli ended up with it and ended up settling after a couple of days. And it was a very volatile situation. We tried it in front of Justice, well, he was Judge Benson at the time, and there was a fee dispute, and I didn't want to sign off on it until they worked out the fee dispute. And Benson said, no, I'll take care of it. And I was young and stupid enough to agree to that. So I settled it and got the check, gave it to Belli, and then he didn't pay Cholas. And I was really upset. So my volatile personality helped. I called up Judge Benson and said, do it. And he got it settled.
Rough time frame for that? The 80s?
80s.
Thank you for listening, and please join us next week as we continue this conversation. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.